All right, everybody, it's time. Let's go ahead and get started. So welcome, first of all. We're so happy that you're here. Welcome to our educational webinar. You've got questions, we've got answers, top compliance inquiries, and how to avoid common pitfalls. Just a couple of housekeeping items before we begin. We muted everyone when you joined the call today. We do want you to ask questions. This is a Q&A webinar. This can be done via the Q&A function at the bottom right-hand side of your screen. We do have a host of panelists that are subject matter experts that can help you during the webinar, and they may save your question for either like a repetition exercise or to ask me directly at the end of the webinar, but we really want to hear what you have to say in the scope of what we're discussing today. ERISA, Section 125 compliance, et cetera, and employee benefits compliance in general. The session is being recorded, and you will receive a link to the recording and a follow-up email. We will also post it to our YouTube channel. And our presentation has been approved for continuing education credits for HR professional designations, and a certificate of completion along with the activity code will be emailed to participants who attend the live event, as well as any after webinar handouts that we provide. And we do have quite a few today, which is kind of exciting. One of Pinnacle's core values is learning, which is why we host these events. Pinnacle is a top 50 bank. We're headquartered in Nashville, Tennessee. We're located across the Southeast and most recently moved into serving the community of Bowling Green, Kentucky, which is our first metropolitan office in Kentucky. So we're really excited to expand our service area. We offer a full range of banking, investment, trust, mortgage, insurance, and benefit products to both employer groups and individuals who want a comprehensive relationship with their financial institution. Quick disclaimer, the information that we provide to you today at 2:02 p.m. might change at 2:03 p.m., considering the urgency in which our regulatory bodies on the state and federal level are passing laws. So this is what we know to be true as of the time of the webinar today, August 24th, 2022. I do think that's the first time I've ever really had to say that. There's been a flurry of legislation. The information provided is for educational purposes. We aren't providing legal, tax, financial, or medical advice. So please do consult your legal counsel or your tax advisor for your particular circumstance. It's me. Hi, my name's Fern. I am the compliance officer for the Pinnacle Health and Benefits team. You may know me if you have attended one of our events or we've met at a conference. That's my fancy like LinkedIn headshot on the left. I've been in this space for about 15 years. I love it. I love compliance. I love employee benefits. I love serving people in this space. Not everyone can say that about their role, so that's really a gift to me. One thing I do think is fun, you know, we all see ourselves in this professional light. You know, I want to share with you a little bit about like who I am outside of work. So this is my fun Fern photo on the right with me and my family. We're hiking the Linville Gorge Wilderness at the beginning of this year. You know, a really fun icebreaker is, you know, would you rather? Or for me, if you ask me, would I rather go to the beach or go to the mountains, I'm 100% all the time going to tell you the mountains. I went to Appalachian State University, didn't graduate from there, but went there, super fun. So I'm always going to kind of lean in that direction. That's kind of our thing. So enough about me, let's get into the webinar. Question number one, is my plan document compliant? I get this question a lot. And the reason is if you're offering if you're an employer or you're a broker who's servicing folks in this area and advising people in this space, if you're offering an employer-sponsored benefit plan, one or more government agencies likely requires you to have a written plan document of some kind. So really that big question isn't necessarily, is it compliant? Is it good enough? Is it going to stand an audit? Is it going to be good enough for these regulatory bodies? And tongue-in-cheek, my answer in my head is maybe, I don't know. I do not reply to people like this. It's just my first initial, like, well, let's dig in further. It's better, in my opinion, than answering a question with a question, which sometimes does happen, especially for, you probably are used to that with like attorneys, legal folks, compliance people. Sometimes we need more information. Now, if our team is preparing documents for your flexible spending account or your HRA plan that we administer, with a fair amount of certainty, know that we're administering your plan according to your written plan terms. We have a lot of intake documents and questionnaires, and sometimes that's what it takes, really, to get that information for us to prepare a document for you. So compliance and legality and would it withstand an audit really just depends on a lot of factors. It depends on what you offer, Facts and circumstances are really important here. So kind of the biggest question is, who are you? Like, who are you as an employer? Are you subject to ERISA? ERISA is the granddaddy of legal terms, which we'll get to that in a little bit as far as employee benefit law. It requires certain legal benefit language to be provided and disclosed to plan beneficiaries. And then do you offer benefits that are subject to ERISA? They don't always go hand in hand, that if you are an employer who has to adhere to the law, that maybe all your benefits may not be subject to it. Do you offer pre-tax benefits? The IRS states that you have to have a written pre-tax Section 125 document. And that's usually in addition to any ERISA documents that you may or may not have to provide. And then the question, like, how old are your plan documents? The IRS doesn't necessarily have specific guidelines as to how recent your plan documents have to be. If it's just a straight, like, premium-only plan document where you're doing the premium conversion for health insurance benefits or HSAs, you just have to be administering your plan in accordance with what you've written down. But ERISA, on the other hand, requires that you have to restate your plan documents every 5 to 10 years, depending on if you've changed your plan terms or operations. And honestly, lately, within the last 2 years, with COVID legislation, ARPA, COBRA changes, run-out changes, the changes to Dobbs versus Jackson, where we're redefining what it really means to provide health care in certain terms across states. If you haven't updated your document yet, you probably will need to. So just overall, my answer of whether or not a document is compliant when you send it to me really is based on so many different factors. But first of all, I want to really dig into what ERISA is, because I'm going to say it a million times during this webinar. So ERISA is an acronym. It stands for the Employee Retirement Income Security Act of 1974. It governs certain employer-sponsored benefits on a federal level. It offers certain requirements or requires certain things and offers protection for plan sponsors and plan beneficiaries in a litigation situation. Now, oftentimes plan sponsors and brokers and even people in my space see ERISA as a scary, overbearing legislation. It requires a lot of paperwork. This is all true. But the good thing, again, is it does offer some plan protections for everybody involved, including plan administrator, plan sponsor, and beneficiaries. And we're going to discuss that further in with some examples. One really big, important part of ERISA is that it requires that plans operate their plans according to the written plan terms, and that you act in the best interest of plan beneficiaries, which is fiduciary responsibility, a really big deal, which in a soundbite just means have integrity, do the right thing, make sure you have it written down so that we can prove you did the right thing. Now, ERISA is enforced by the Department of Labor, and it's 3 bodies, EBSA, the Employee Benefit Security Administration, the Pension Benefit Guarantee Corporation, and then the Department of the Treasury and the IRS. Somebody this week, which you already heard me say it, told me that they refer to ERISA as the granddaddy of employee benefit law. So naturally, I call it the pawpaw law because I'm from Alabama and I'm from the South, and that's my pawpaw right here. And I couldn't help but just kind of think about the fact that, like, relating this to your life, oh, and that's me. In the 80s, probably the last time that somebody, addressed IRS regulations. So anyway, we're talking about some really old laws here, and I just thought that this is a really cute way to kind of bring it down back to the ground, this huge overbearing law. Think about your pawpaw or a cute family photo, and, maybe it'll make you feel a little less nervous and not be so overwhelmed. But great example of, like, we are really dealing with some older regulations that have changed throughout the years. I like to refer to ERISA as an umbrella. Not everyone has an umbrella, and not everyone needs an umbrella. But first, I want to talk about those, like, employers and those plans that are waterproof, so to speak, so they don't need to fit under this ERISA umbrella. You are not subject to ERISA if you're, or governed by ERISA if you are a church, you're a municipality, or a Native American tribe, and neither are the plans that you offer. Also, there are just certain plans or benefits in general that are almost never subject to ERISA, and you don't want them to be subject to ERISA. They're health savings accounts, dependent care FSAs, regardless of who sponsors them. And then that pre-tax document that you have, your premium-only plan document that houses your HSA, the pre-taxing part of this is not an ERISA function. That's a Section 125 function. So that's, you're going to hear me talk about this separately today. You have to have that separate pre-tax document in addition to your ERISA documents if you're subject to ERISA. Now, let's look at those employers and benefits that are subject to ERISA. So they're under this umbrella. Any other employer besides the church, municipality, or Native American tribe, you're subject to ERISA. If you offer an ERISA benefit, then you're going to have to start requiring disclosures and potentially do some additional reporting. Some of the benefits that you offer, maybe not all of them, are going to have disclosure requirements. And some of them may not surprise you. Medical, dental, vision, for example, shouldn't be a surprise. But things like health reimbursement arrangements, health FSAs, limited purpose FSAs, they're subject to ERISA, ERISA claims rules, ERISA disclosure rules and notices, et cetera, and appeals rules as well. There are some gray areas here. Like, not every benefit that you sponsor is always going to be an ERISA plan. It depends on the benefits that you offer, the level of employer sponsorship, which is really, really tricky, as well as how you fund them. If they're fully insured and self-funded, ERISA is, again, on the federal level. An example of this is a wellness plan. Let's say you have a wellness plan. It pays for your gym membership if you prove that you walk a mile a day. That's not an ERISA benefit. Now, when you start adding things in, like you have to get a biometric screening, you have to get a health risk assessment, you have to get blood work, you have some kind of health component or a health outcome, and then suddenly that wellness plan is no longer exempt. And what that means is it has to have its own plan document, its own summary plan description, its own wellness notifications, participant notices, and a lot of examples. So again, ERISA is requiring that you have to have these things provided to your beneficiaries. So every single benefit that you offer, if it's subject to ERISA, has that disclosure requirement. You're probably going to feel like I'm going to beat you over the head with this, but it really is truly a question I get a lot, worded a lot of different ways. So I just want to reiterate that. And because of this overwhelming disclosure requirement, a lot of times many employers will have a wrap plan document created for them. Sometimes you might hear it called a mega wrap. And really what that does is it kind of wraps around, think of saran wrap, like all the saran wrap coming across all these different benefits that you have, all these different summary plan descriptions, and like making one big plan. And then it takes some of that information in the ERISA language that you're required to provide and kind of fills in the gaps where the other documents that you have don't meet those requirements. It allows you to save time administratively and save money because having ERISA counsel create a plan document and SPD for you for every single benefit is multiples of thousands of dollars, and nobody wants to do that. So that's going to take me into my next frequently asked question. I have a wrap plan document my broker gave me. Do I need other plan documents too? Unequivocally, the answer is yes. It's always yes. a wrap plan document, again, it wraps around all those benefits, and to be fully compliant, if you open your wrap plan document, let's say you have one, it's going to be about 30 to 45 pages, maybe a little bit more. It's a shell. It's a shell document, and you'll see a list of all the benefits in an appendix that you offer. Should outline some eligibility as well, if done properly, as well as your carriers. It's not just enough to list it. Again, you have to include those subsidiary documents, and you can't just incorporate them by reference. So what I'm going to do, I'm going to compare preparing a wrap document to packing a vacation bag. So you see your checklist on the wall. It's your packing checklist. It's all the things that you have to include in your suitcase. You can't just take your checklist and go on vacation. You have to pack the things that are written on the checklist in the suitcase, including your passport, your wallet, your shoes, your hat, any other clothing. Otherwise, you're not ready to go on your trip. And that's the way the DOL sees wrap documents that are incomplete. You basically left town without everything you needed. It's going to cost you a ton of money when you get there. You may not even get there. Ton of money and headaches the same way that you're going to have a ton of money and headaches if you don't have your documents withstand a DOL audit. Now, in comparison, this is the proper way to prepare a wrap. So as you can see, my checklist is gone. My passport's gone. Everything is packed up nice and tidy in my suitcase. So the DOL wants you to pack that checklist too. Include the checklist in your wrap. It's got, that is, you know, the 45-page document that you've been given by your broker, or whether you've done that on Think HR through like an HR administrative system. You really have to pack this all together in one suitcase, and that is compliant. So when you start thinking about this, if you offer a whole lot of plans, your wrap document is going to be huge, potentially 300 pages or more. So here is, it's an example. It's not exhaustive, but an example of a summary plan document checklist for ERISA medical plans. This would be one component of a compliant document just for the medical benefit. The checklist alone is probably 5 pages. So there's a really whole lot of information that you've got to supply in an ERISA compliant document. These things can be missed and overlooked, and the booklet that your carrier gives you does not suffice. That's the reason for those shell documents. So you probably sponsor more than just a health plan, which is why this has suddenly become a humongous, overbearing, like tree-killing document. One thing I want to mention on this checklist that's also true for Section 125 plans is eligibility. So here's an example of when I do answer a question with a question. If I hear a question like, can my employee drop coverage, or can my employee change this, or is this person eligible, I will ask you, what does your plan document say? And if you don't have one or you can't find one, number one, you should get one. I'll then ask you, do you have any other plan materials that outline your enrollment operations, like maybe open enrollment materials, where you might have included eligibility information, and sometimes that suffices just for that moment. You still need that document, but we can still get to the answer for that particular issue you're having for that employee. Have you ever, if you don't have open enrollment materials, like have you set a plan precedence? Has this happened before? What did you do? Ultimately, at the end of the day, like if you don't have any of those things, I'm going to give you the regulations and what they say, and I'm going to tell you you should probably lean into the most lenient way to solve the problem because you don't have it in writing and you never disclosed it. So you're going to keep that fiduciary responsibility thought mindset of doing the right thing for your plan participant. Just make sure you have it in writing. And by the way, we are providing a copy of this checklist at the end of the webinar, along with some other checklists and frequently asked questions. This particular checklist does include a list of very common participant notices that may or may not be included in an ERISA plan document and SPD. It's not exhaustive. This will by no means ensure that the DOL will come in and audit you and you're going to be good. But it's a really good example of really what all it takes to meet the DOL's audit requirements. And there are some notices on here that non-ERISA employers do have to provide, like CMS notices for Medicare Part D disclosures. So just keep that in mind as you're reviewing it. Really quick, we talk about the humongous document that sometimes you're going to have to mail. Generally costs about $5 per person, and it's because they're hundreds of pages. I don't love this in any way, shape, or form. You know, one, I don't want to kill a tree. Two, I don't want to print something that no one's going to read. I want my employees, and I want your employees to understand their benefits, but people learn in a ton of different ways, and reading a humongous document written in legalese is just not the way to get there. It's just what the DOL requires. And, you know, if you're not subject to ERISA, you've got that Section 125 plan document. There are sometimes disclosure requirements to that too. Or if you are subject to ERISA and you're pre-taxing your benefits, that's just another document that you have to give. So, and yeah, that's why it's so important to come to your employees in many different learning capabilities in different ways. Yes, you have to satisfy the disclosure requirement, but it's really all in all trying to get them to understand their benefits to start with. You can deliver disclosures electronically if you meet certain requirements. You have to receive signed consent from your employees. You have to ensure that your participants have work-related computer access as part of their job. And you have to try to take steps to ensure actual receipt of the electronic document, which might include tracking. You may have different populations. You might have an office staff, and then you may have a staff that's out in the field. According to this safe harbor, your office staff could get the electronic disclosures, but your folks in the field can't. You would have to provide printed copies, mailed copies. Some people take a little bit of liberty with this and just try to make a good faith effort. You know, you can dip your toe in the risk pool as far as you're comfortable, just telling you what the DOL requires here, which is my main goal at the end of the day. Question number 3, do I have to file my plan document with the Department of Labor or the IRS? And the answer is no, not unless they ask for it, but not like affirmatively. You might have other reporting requirements, though, outside of an audit situation. So I'm going to talk really quickly about Form 5500. What it is, in case you're not familiar, it's an annual report. It's required to be sent to the DOL annually. They use it to determine trends and sometimes financial information. It's more heavily regulated on the 401k side, which is also subject to ERISA, but this is the health and welfare aspect, so a bit different. But not every employer who's subject to ERISA has to file a 5500. So the triggers are, 1, you got to be subject to ERISA. Churches, municipalities, they don't have to file them. I do hear sometimes where people are like, oh, my client's a nonprofit, they don't have to file a health and welfare 5500. That's not true. So just keep that in mind. The ERISA exemption here is only for churches, municipalities, and Native American tribes. The second trigger, you have to have 100 or more enrolled employees on the first day of the plan year. And then the third trigger, which I'm not going to go deep into because honestly, every single one of these questions and topics I could spend hours on, which you guys would love. But you may be a small plan, meaning you're under 100 and have to file a 5500 if you hold your plan assets in a trust, or you are a multiple employer welfare arrangement, which is also called a MEWA. And at that MEWA level, you are also subject to M1 filing requirements. If you hold your plan assets in a trust and you're a MEWA that's been set up correctly, this shouldn't be news to you. It's pretty rare. It's been less than 1% of 5500s I've ever prepared have had to have a trust requirement or an M1. So just keep that in mind. You would be aware. Someone would hopefully make you aware if you had those requirements at all. There are some triggers that people tend to overlook as well, like when that 100 or more enrollment happens. You really need to keep an eye on your life benefits, your employer-paid disability benefits, and interestingly enough, health reimbursement arrangement benefits that aren't integrated with your health plan. And when you don't integrate your HRA with your health plan, like you'll give, someone might decline coverage for your health plan, but you allow them to have other employer coverage and still get the HRA money, that's like 100% funded money. That's the benefit that takes you over 100 the fastest, these group life plans, the disabilities, and the HRAs and things like that. So those are the ones to keep an eye on in order to see when you're going to go over that threshold. Now, Form 5500s are due 7 months after the plan year end. There are extensions available. And another common question I get is, can I print out the 5500, fill it out by hand and mail it in? No, you have to do these electronically. The DOL does not accept paper submissions. And this is just a handy little tool. I still use it, but I used to lean on it heavily in my former life, where the team that I led filed 5500s for our larger clients. Take a snapshot if you feel like this is useful, or if you want the slide deck at the end of the webinar, I'm happy to give it to you. I actually cut this out and put it on my wall. So if someone calls and asks me when's my 5500 due, I can just drag my finger across it and find that out for them. So if you are someone who prepares 5500s, it's great. If you're a client who maybe you don't have a wrap and you've got a ton of different contract years and you're just not, if that works for you, this might be useful to you. If you're a broker and you have obviously a ton of different clients with different plan year ends, this could be just a really snazzy little printout for you. So the DOL does audit, as we've talked about. There are penalties that they assign to you. The only way they're probably going to know you're not in compliance is because a participant is mad at you. Something will come up, some kind of litigation will happen. So just so you know, they don't generally actively look at Form 5500s and go, I'm going to pull this person today and go audit them. So there are a fair amount of quite extensive and expensive penalties. I'm not going to speak to all of them on this list, which, by the way, is not every single penalty they could give you. But I do want to talk about the failure to provide a summary plan description. A compliant one is $110 per day per person. That stinks. Failure to file a Form 5500 timely, and the DOL discovers it during an audit, that assignment of penalties could be $2,400 per day. Thankfully, because that is aggressive, there are ways to voluntarily tell on yourself and get yourself in compliance through the DFVC program. It's the Voluntary Delinquent Filer Program, and the penalty is $10 per day, up to $2,000 for that plan year. And no matter how many years your plan is delinquent, that's capped at $4,000 total, as long as you file appropriately and it doesn't become delinquent again in the future. A little bit of an in-the-weeds tip, you know, we've had people who have, I know people who have had DOL audits, and during that time, the DOL is going to give you a super duper hefty list of things that they need from you in a very short period of time, including all of your legal plan documents and summary plan descriptions in the last 3 years of your Form 5500s, among other things. So you might be looking for that 5500 and you don't have it. They usually give you a very short time frame, like I said, 30 days. So the first thing you should do when you get that notification is get counsel and ask for an extension. But during that short period of time or that extended period of time, you still can use the delinquent filer program and have capped fees and capped penalties as long as you submit it before you send everything to the DOL. You don't want the DOL to tell you that you're delinquent. You go ahead and do it yourself. It's kind of a rush game, but I would say in this instance where you're looking at huge penalties, it's worth it. So question number 4, I was asked this last week. What is the benefit to IRS compliance if they don't actively audit plans? It's a valid question. The benefit is staying out of trouble. So we know that the IRS can audit plans like the DOL. They don't currently have an active task force. We know that they audit humans in their individual tax returns, and we know they do corporate tax audits. But they're not walking around auditing Section 125 plans, which they do audit 401k plans, so keep that in mind. This is a separate situation. 401k plans are heavily monitored and regulated, and there's like a checklist on how to stay in compliance, which doesn't always exist in the space of Section 125 compliance. So again, it's truly a because the government says so answer, but in the private world, mergers and acquisitions happen all the time. And if you are looking to be acquired or you're a part of like a merger situation, it is not uncommon for both entities to want to know what kind of risk they're getting into through their partnership, through a merger and acquisition. And groups have been asked to provide, you know, their non-discrimination testing results, their Section 125 plan document, because the more risky you are, you know, it's going to be harder to go through that merger and acquisition. So that alone has encouraged some people to be compliant in this space. But, you know, I do understand it's that risk-reward situation. So talking about non-discrimination testing, it's supposed to be done annually, but I want to quickly talk about why it's required by the IRS. So it is to ensure that highly compensated employees and key employees don't receive greater tax advantages than non-key employees and non-highly comped. And I'm not going to go over the definition of, you know, that indexed highly compensated salary limit. It's different depending on the plans that you offer. So that's kind of an important notation to keep in mind. But as far as like who's supposed to do the test or what types of employers are supposed to do the test, there's no exemption here. So any employer that offers pre-tax plans is supposed to perform non-discrimination testing. So if you're a church and you're pre-taxing your benefits, this is supposed to be a requirement for you. When do you have to test? The last day of the plan year, and I absolutely hate this regulation. And the reason for this is because if you test on the very last day of your plan year and you fail, you have like no time to fix anything. And you can't bring your plan back into compliance in one day. So a best practice is to do this multiple times a year, although logistically that can be difficult. Most employers, if they test at all, test about 3 months prior to their plan year end. So it's considered a mid-year test, but it gives you that time to rectify any failures, because if you don't, you could risk all highly comped in some way, shape, or form having to impute income, meaning reclassify their income from pre-tax to post-tax on their W-2, you know, box one gets bigger, rather than like perhaps a portion, or you really just can't mitigate the failure in that short amount of time. So let's say what happens if you do fail testing. Well, it really just depends. What IRS code are we looking at? Why did you fail? There's tons of ways to kind of mitigate that and tons of ways to fail, which sounds really scary, but there's not a ton of, there are generally prescribed methods for fixing a failure, but no one in our space agrees on how to do it because it's just not been revisited in such a long time. The IRS Code 105H regulations, which govern self-funded health plans and like HRAs and health FSAs, those are from like the early 80s. And so much has come and happened since then. It's just really hard to kind of navigate, like, what do you do? So you're not likely to find two administrators who are going to agree on how to tell you when to test, the data that they require for you in order to test, or their prescription for failure. So that's, you know, why do it, right? That's the question. Here are some red flags. Let's say you never do a ratio test. Part of the plan testing does require some math. Here are some plan designs that may fail just based on their plan design alone. So any plan design that allows highly compensated employees or key employees to join a plan sooner than a class that doesn't have key employees or non-key employees or highly comped in it. So like, you just can't give somebody better benefits by class, earlier start date, less hours to work, better contributions. Anytime they're different, it's just a red flag to stop and take a look at your plans. It doesn't mean that you can't do this. It means that you have to test to make sure that it passes testing on both levels. You're going to have 2 IRS plan documents. Let's say you have a class of salaried employees, and then you have a class of hourly employees. This is not uncommon. You have to have a salary plan and an hourly plan, and then you have to test them both in the math level. So all those 2 plan documents does is say you don't automatically fail, but you still have to do the mathematical ratio test. And here's a big note. The carriers are going to let you underwrite this way. You can set up different plans by class and hourly, or let people join the plan sooner or later, or have different contributions. The carriers don't care. The IRS does care. And so those 2 are not in cahoots when it comes to making sure that you're in IRS compliance. So just keep that in mind as you're, designing for your benefit plans. Now, in addition to having a plan document, doing testing, you're supposed to substantiate expenses. And that's because it's a tax-advantaged benefit. Now, from an HSA standpoint, this is self-substantiation, just keep your receipts. But from a health reimbursement arrangement standpoint, an FSA standpoint, the IRS requires the third party reviews your expense and approves it for plan substantiation requirements. So just so you kind of know what an IRS is looking for as far as proper substantiation, whether it's the health FSA plan or an HRA, provider information, date of service, it has to be incurred, in the current plan year, services received, and the total amount you're claiming is qualified. So, if you pay with your debit card, sometimes the amount you pay may not match your EOB, it may not match your walkout statement. Sometimes you have providers that want you to pay like an estimated amount up front. And then when it comes time to reconcile on the end of it, it's actually really difficult. So you want those things to match. You want to do your best to provide that information fully and completely so that the IRS doesn't contend that it's an eligible and a taxable wage. So penalties for noncompliance. Noncompliance in any one of these areas could disqualify the plan, which means everything is taxable for everyone back to the plan inception. It could disqualify highly compensated employees or key employees and make some or all of their previously pre-tax benefits now taxable. Honestly, no one really knows. The IRS, again, doesn't really audit plans, and in personal, one-on-one conversations that we have with them, getting into compliance, they have different ways that they say to do it, but just aren't aggressively after folks. We do know that, again, that corporate tax audits are normal. They may add, the one instance I know of somebody being audited where any kind of Section 125 information came up was during a corporate tax audit, and they were asked for a copy of their Section 125 plan document. They were not asked for anything else. But keep in mind, the Biden administration just passed a law to increase IRS governance over the next 10 years up to 87,000 auditors. Are they going to audit plans? We don't know. We do know they plan to focus on high wage earners and do corporate tax audits, but is one going to lead to the other? Are they going to beef up oversight in this plan area? We just really don't know. So in my opinion, it's better to at least try to get into compliance, stay in compliance. And if you're not, and you're audited, do that hurry up method that we talked about. Question number 5. This is a hot topic. What are employers doing in light of the Roe v. Wade being overturned by Dobbs versus Jackson? Before we get into this, I do want to say that we know that this is a sensitive topic and it's a serious topic. The information we're providing to you today is apolitical. We just want you to have the information that you need based off of what we know right now so that you can make the best decisions that are available to you, whatever that might be. Education really is key into making good decisions, and we want to be a part of that for you and helping you navigate really what, we talk about avoiding common pitfalls. This is a pitfall. This whole thing is a pitfall. So we want to be here to hold your hand and help and be sensitive to the fact that there are a million different opinions on both sides of the aisle of whether this was right or wrong. But we're just here to help, and we acknowledge that. So what are employers doing? It depends. It depends on the employer, depends on the state, but there are options. Now, just a recent survey that was sent to 305 large employers, which is about 4 million employees total, Of those who responded to the survey, 35% of these employers were offering some kind of either abortion coverage or abortion travel or medical travel benefit. 16% plan to offer this kind of benefit in 2023. 21% are considering it, and for those who already have some kind of benefit built into their plans, 44% are enhancing it. There are some employers who are looking to decrease the benefit because they have to, or potentially because they want to and they can. So this kind of just runs the entire spectrum of what's coming up in these questions that we're receiving and that you're probably receiving as a broker or you may be receiving from your employees. So just to recap, in case you didn't know, abortion is now regulated by the states. There's a multitude of state trigger laws that ban abortion either completely or to some degree. States are currently working to limit it as well or increase it and make it more accessible. So you do have states that already require abortion as part of minimum essential coverage at the state level, California, for example. And then there's Texas. In Texas, it's a felony to provide an abortion at any time after the date of conception, except to save the life of the mother in an emergency situation. There are fines, hefty fines as well. And not only is it a criminal offense, anyone who aids and abets in the procurement of an abortion can also be sued by anyone, so it's a civil matter. So if you think about an employer who operates in multiple states, Tesla, for example, is in California and Texas. Like, this is kind of an HR nightmare for them. How do you do this? You have to consider all the state laws that you operate in or that you may have an employee that is living in and working for you as you're thinking about coverage and the legality in this area, in this changing area. So the abortion protections that exist right now, we're going to talk about how ERISA protects employers at this moment from the federal level. Self-funded medical plans can claim an ERISA preemption. This is an example of that. This means that any self-funded medical plan can design their health plan to include abortion access as desired or travel benefits as well. Now, self-funded, for those of you who don't know, self-funded health plan, it means that, like, you as the employer pay the claims on, you know, your participant going to the doctor, you pay the claim, like you write a check out for it. You may have some kind of stop-loss insurance coverage that covers you from, like, a catastrophic claim. But in general, like, because of that, you're allowed to design your own health plan. You didn't buy your insurance coverage on the state level. So ERISA preempts any state law. On the other hand, fully insured medical plans, you're going to have to adhere to the state law that you live in and where you got, where your certificate was assigned to you. So if you live in Tennessee, you got it through a Tennessee insurer. Tennessee state law is going to, you know, preempt ERISA law in that case. So it's going to be mandated at the state level. Currently, medical travel is already covered and recognized by the IRS under Code 213D. Now, this includes all legal medical travel expenses, but there are limits that exist. So it's limited to $50 per night for lodging, and then 22 cents per mile traveled. So this is true for your health FSAs. This is true for any 213D HSAs as well. But this just means that the procedure has to be legal in the state in which it occurs. Now, there are some emergency protections that exist under EMTALA, and this ensures that where any hospital emergency facility accepts Medicare, must also ensure that it provides all emergency necessary steps to save a patient, even if that means performing an abortion. This has existed for some time, but Biden just doubled down on this in communications and executive orders. And Texas is currently suing the administration for this, for what they consider an overreach. So, like, having said that, I expect all of this to be litigated at some point. You know, I keep talking about it's not clear if a self-funded health plan operating in Texas or in some states that's limiting abortion, like, can the plan be sued? Like, is ERISA going to be able to withstand this? Like, we don't know. This is very new. This has never really been challenged before. It's unclear if, like, a TPA could be sued for processing and paying an abortion claim. So we're going to see this shake out over the next, I imagine, few decades. I mean, you know, when the ACA passed, there was a ton of litigation that happened that's still really being reviewed. So this is not going to be a quick fix that everyone's just going to know the answers immediately. So I was telling a teammate yesterday, like, you know, we have to watch the news, and to be quite frank with you, like, that's the fastest way to ruin my day. I do not or read the news. Like, it's just so overwhelming. But at the end of the webinar, I am going to share a resource that I use that delivers employee benefit information to you once a day that I think is really helpful. It's from thought leaders in the industry, TPAs, attorneys. It's well varied, and I think that's really a good way to kind of subscribe and, you know, narrow focus what it is you're trying to get your information on. Now, recently, other agencies did add additional commentary, and they doubled down on protections, like what's required from the contraception perspective and some other protections. So non-grandfathered health plans must cover contraception, including Plan B. Also, the FDA approved abortion pill access recently via mail. So the Biden administration wants that to stay protected. It's going to get litigated. I think it actually is being litigated. You know, the Affordable Care Act doesn't mandate abortion coverage. Again, that's generally determined by the state in terms of, like, the other things that kind of make up their state health plans that you can buy on the exchange. They don't mandate vasectomy coverage or condom coverage, and although these are 213D eligible expenses. So, you know, I'm just noting this here because California is considering mandating vasectomies as preventive. There's been an uptick in these procedures, and as well as, like, over-the-counter prophylactic purchases. Now, the Department of Health and Human Services and the Employee Benefit Security Administration also intend to ensure the pregnancy non-discrimination rules, which would include being pregnant and any kind of pregnancy termination. And then privacy protections were reiterated to physicians and also anyone that wants to, you know, ensure that their browsing history may be protected, data usage and privacy within certain applications on your phone, like period tracking apps. They potentially will and have come into the spotlight or could be a part of a subpoena. So there's a lot going on, federal, state levels, all around. But I want to talk about some plan design options. One, get an attorney. You're going to really want to talk to somebody, or at least have, you know, the ear of counsel. Super duper important. Nationally recognized businesses, and you probably heard this on the news, like Amazon and Meta, they announced that they intend to provide travel reimbursement for those who seek an abortion outside the state because it may not be legal or may be limited in the state in which they live. This is currently an option. It will be litigated in some state, trust me. You can add this to your current self-funded medical plan. You can also have a standalone HRA. Now, if you have a standalone HRA, there could be some financial limitations to the amount, and then you also have to consider whether or not you're going to integrate it with your health plan. You have to consider Mental Health Parity Act requirements. So this could be kind of a competing regulation here as with mental health parity, which the DOL does care about. Like, they're super, super, super duper, like, into it. For good reason, but you have to cover mental health and addiction services the same as other, you know, medical and hospital requirements. You can't limit it. But there could be a competing issue here. We don't know if the Biden administration is going to enforce MAPIA, you know, against abortion coverage. I think they want both to be true in the same light, but this is just something to consider. You have to consider potential COBRA obligations. You know, if you make the plan subject to ERISA, it's not an accepted benefit. You've got COBRA, you've got plan document requirements. Again, you may have to wrap the benefit in your wrap plan. You have to think of HIPAA, privacy, and substantiation concerns. So someone on a plan is going to have to submit a receipt or documentation showing that they received abortion care. dates of service, et cetera, in order to be eligible. And then that brings up liability, like who's going to be liable for that? You know, employers, you need to be looking at your contracts with your TPAs. TPAs, you need to be looking at your contracts with your attorneys. What's your overall take on this? And you have to determine, like, your willingness as a company and an organization to be prepared in this space, because it's really important. And there are some plans who are considering adding this to employee assistance programs, just keeping in mind that any EAP benefit that offers a significant health benefit is going to be subject to ERISA. And having said all that, what you choose to do is going to be different state by state, especially if you're a multi-state employer. My current suggestion, and the current suggestion of many people in this space, if you're going to do medical travel enhancements, medical benefit travel enhancements, don't keep it specific to one benefit or one procedure. Bank of America, for example, is increasing their medical travel, but it's for cancer. It's also for abortion. It's also for things that people tend to travel across state lines for. You know, lots of people who get cancer, they want to go to St. Jude, and, you know, all those things are quite expensive. So they're really trying to make it a beefed up benefit, not just for one population. That helps with non-discrimination issues. It would help you in a lawsuit, specifically if, you know, you're being charged with, you know, providing abortion access as a plan on a state where you can't do that. It's going to give you a little bit more of a cushion. Again, take that opinion to your counsel. We've had some employers who know they can't increase abortion benefits due to multiple reasons. It could be they don't want to. It could be that the state that they're in, it's just not going to happen. We've had some employers increase their maternity benefits because they had a huge deductible, and they know that that expense sometimes can be a decision maker in what someone chooses to do. So their HRA pays for all maternity deductible expenses. They've also beefed up their short-term disability benefits. We've had some employers carve out an HRA just for vasectomies because vasectomies weren't preventive. So again, watch the news, stay on top of the changes, lean on your counsel, lean on your administrators, ask questions. It's changing every day. So we're here to help when we understand. So just really quickly, some compliance partners and tools. Zenefits has a really great compliance calendar. You can upload it to your Outlook. ThinkHR, now Mineral, you can prepare some of these participant notices within ThinkHR. You can prepare a WRAP plan shell document as well as a Section 125 premium only plan documents. And, you know, they do these with their attorneys that are on staff or that they externally hire. So it's a great resource. SHRM, Society for Human Resource Management, talk about trying to figure out what other employers are doing. That's the space. The summary plan description guide and the notice checklist that we give you, again, not exhaustive, it's just an example. The Department of Labor reporting and disclosure guide is like the daddy document. So you can always go, you can Google that specifically. It'll take you right to it on the DOL's website. It'll tell you who's required, when it's required, how often, et cetera, as far as disclosures. And finally, that source I said that will narrow down really important topics to you and send it to your email. It's benefitslink.com. I do subscribe. I get really great information from there, and I highly, highly suggest that if nothing else that you do here, I would subscribe to benefitslink.com because it's a really great information tool. All right. So the Q&A webinar. If you have questions, we'd love to answer them for you. So please shoot us a message in the Q&A section. If you think of something, you can email us at health@pnfp.com. Emily, do we have any questions? Have we had anything that's been frequently asked as I've been, you know, beating folks over the head with ERISA?
No, I've got a couple questions for you real quick, and I'll ask my most recent one first because I think it's really important. So as an employer, one of our groups regarding Form 5500 and other ERISA reporting, they depend heavily on their TPAs for these filings. What pitfalls may result from this?
Well, you as the employer are always going to be like the party that the DOL is going to audit. So there's nothing wrong with relying on your partners. You should. You have to have that trust. You have to have that give and take. But I do think that it's something that you should just be aware of. So if you're an employer who has a RAP plan document, you know, every year it would be a really great time around renewal just to look at your benefits and go, has anything changed? Do I need to change my plan documents? And then, you know, 7 months after your plan year's over, you're going to have to file a 5500. So maybe make a reminder in your calendar to just follow up with your partners and make sure that that's done for you. One positive on the upswing, your TPAs generally are going to have an easier time filing it for you or your compliance partner who prepares these than you are. Doing it on your own is a nightmare, so I don't recommend doing it unless you're a CPA or you have like training in this specific area. So it's not all bad. There are some really great, you should lean on people and trust their expertise and they can help you.
Awesome. I got one other question. What is a MIWA?
Oh, so it's called, it's a 4-letter word. I'm just kidding. It's a multiple employer welfare arrangement. They're very tricky, but the purpose of it is, on some level, is that you have a bunch of different employers who are not affiliated. And when I say not affiliated from a legal level, I mean like there's not enough common ownership between the entities that they could be considered what's called a controlled group in the IRS's law. So you have to be a controlled group to have all your different subsidiaries and whatnot participating on your employer benefit plan. Well, MIWA allows you not to do that. So a good example of this is like a bunch of attorneys who maybe they have like small practices, they want to come together and they want to have that buying power and the underwriting buying power of coming together, almost pretending like they're one employer and going to a carrier and getting a better benefit plan, cheaper, better benefits. I mean, you know, it's expensive to buy insurance. That's the idea behind the MIWA. You don't have to really have that same ownership to join this plan. Now, in certain states, if you don't do it right, it's a felony. But that's probably the best example I could give you. It's an association plan. You come together with an associated of like-minded groups and you create a benefit plan together. Can be really tricky, so that's something to do with counsel. Good question.
Awesome. And I've got another one for you. Can an employer do their own non-discrimination testing?
You can. So it's tough, but you know, so you can essentially get a POP document off the internet for like $200. Like they're hot potatoes, they're commodities. You know, you want to do it with somebody who knows how to guide you how to do it. But anyway, within some of those premium only plan or Section 125 plan documents are guides in how to do your own. As long as that is part and you have that guidance, absolutely, you could do it. I can't see a reason why not. And it's going to be hard for you, by the way, to know whether you're checking all the boxes, because it's hard for some of us to know if we're checking all the boxes. There is a governing body that, I mean, not the IRS, like a think tank body that kind of goes through. We have conversations with the IRS all the time about like best practices. They're not law. They are just one-on-one conversations, and it's a lobbying group, and those types of things help us tell you how to do it. But no, there's no reason that you can't. Why not? At this point, do whatever is convenient for you and just try to stay compliant.
Okay, I think we've got time for one more.
Okay.
Is being a member of a captive group for self-insured health plans the same as a MIWA?
Generally, no, it is not, because you're not. So MIWA's, again, super duper tricky, so I'm going to try to keep it pretty above board. Buying into a captive and having underwriting on a captive level could be a MIWA, but not always. So it really, I would say in this instance, it's just really important to look at your contracts. it kind of just depends on the amount of like employer like who's sponsoring it and like what kind of documents exist and how it's legally set up. So the answer is it could be, and I hate to answer it like that, but I'll do some research for you. Emily, if you'll just give me their information, maybe we can ask some questions. But always the best thing to do is to look at what you're signing up for, and it should define what it is that you're doing. Great questions, guys. Well, perfect. If there are any questions that come up in the Q&A, I'm happy to, shoot you a direct email, shoot us a direct email at health@pnfp.com. We're really glad that you are all able to join us today, and we look forward to seeing you at our next event. So talk to you soon.